I'm Katie, and I'm currently taking the Real Estate Pre-License course through Metro Brokers Academy School for Real Estate. I want to invite you to study with me on my channel. We will review all the chapters individually, as well as the vocabulary you need to know within each chapter. So don't forget to like and subscribe at the end. Without further ado, let's move on to today's topic. Real Estate Exam Prep Rights Quiz Time with Katie Landers Does Real Estate. Before we get started, let's go over how this quiz is going to work. I will first ask you a question and repeat the question and list out 4 choices, A, B, C, or D, for you to choose from. Once I'm done reading your choices, the timer in the upper left-hand corner will pop, and you will either have 10 seconds, 30 seconds, or 60 seconds to produce an answer, either in your head or out loud like a crazy person, before the answer is revealed on the screen. Let's do it. A private deed restriction can be made ineffective by which of the following? A private deed restriction can be made ineffective by which of the following? A, a ground lease. B, conveyance of the property. C, voluntary cancellation by at least 2 of the affected property owners. Or D, a conflict with zoning laws. The answer is D, a conflict with zoning laws. Several legal steps must sometimes be taken before a creditor can have an outstanding debt satisfied through a sale of the debtor's property. Which of the following may be required? Several legal steps must sometimes be taken before a creditor can have an outstanding debt satisfied through the sale of a debtor's property. Which of the following may be required? A, judgment. B, attachment. C, writ of execution. Or D, all of the answers are correct. The answer is D, all of the answers are correct. Which of the following is correct about an estate? A, it can exist simultaneously with another estate in the same property. B, upon the death of the owner, it either goes to the owner's heirs or to the state by a sheet. C, the owner is always assured of possession. Or D, its duration is either forever or for a lifetime. The answer is A, it can exist simultaneously with another estate in the same property. A homestead might be defined as a family home. Some states have homestead laws which afford some protection for the home from seizure to pay debts of a deceased owner or breadwinner. These laws are designed to protect. Again, a homestead might be defined as a family home. Some states have homestead laws which afford some protection for the home from seizure to pay debts of a deceased owner or breadwinner. These laws are designed to protect A, the mortgage lender, B, the community, C, the breadwinner, or D, the bereaved family. The answer is D, the bereaved family. Bob gives an estate to Jim for the life of Sue. Which of the following is true? Bob gives an estate to Jim for the life of Sue. Which of the following is true? A, Jim has an estate pure autre vie. B, Bob has a possessory estate. C, Sue is the person in remainder. Or D, Sue has a revisionary interest. The answer is A, Jim has an estate pure autre vie. For 10 years, Mr. Jones had verbal permission to park a car in Mrs. Smith's driveway. Mr. Smith sold to Mr. Johnson. For 10 years, Mr. Jones had verbal permission to park a car in Mr. Smith's driveway. Mr. Smith sold to Mr. Johnson. A. Jones had a license from Smith. Johnson may continue it or discontinue it as he chooses. B. Jones' continuous use over 10 years has probably created an easement by prescription, leaving Johnson powerless to revoke Jones's right to continue parking in the driveway. C. Smith's permission for Jones to use a portion of the land for a specific purpose created an easement appurtenant that runs with the land. Therefore, Johnson must allow Jones to continue parking in the driveway. Or D. Jones's use of the driveway was a personal easement in gross that ended when Smith sold to Johnson. The answer is A. Jones had a license from Smith. Johnson may continue it or discontinue it as he chooses. Amy Carson owns 200 acres that are rich in oil reserves. Her ownership interest is fee simple absolute. She may A. Sell the oil rights but retain fee simple ownership in the land. B. Sell the land but reserve the oil rights. C. Sell the oil rights to one party and all remaining rights in the land to another. Or D. Do any of the answers. The answer is D. Do any of the answers. An encumbrance may be defined as all the following except A. Anything that affects or limits the fee simple title. B. The degree, quantity, nature, and extent of interest in real property. C. Rights or interests held by someone other than the fee simple owner of the property. Or D. A claim, charge, or liability that attaches to real property. The answer is B. The degree, quantity, nature, and extent of interest in real property. In order to be effective, a lien should be A. Recorded, B. Published, C. Renewed, or D. Delivered. The answer is A. Recorded. The grantor of a life estate may retain A. Revisionary estate, B. Less than freehold estate, C. Remainder estate, or D. Fee simple estate. The correct answer is A. Reversionary estate. Jones, a life tenant, grants Smith an easement across Jones's land. Later, Jones dies. The easement will go to Jones's heirs, B. Terminate, C. Remain Smith's, or D. Not be enforceable because a life tenant cannot grant an easement without committing waste. The answer is B. Terminate. The right of enjoyment includes some rights over adjoining land, including the right of A. Lateral support, B. Eminent domain, C. Prescription, or D. Possession. The answer is A. Lateral support. A provision found only in a deed which subjects the owner of land to certain restrictions is called A. Covenant, B. Condition, C. Prescription, or D. Necessity. The answer is B. Condition. Statutory liens, which are also specific, include A. Judgment liens, B. Mechanics liens, C. Mortgage liens, or D. Estate tax liens. The answer is B. Mechanics liens. General liens that encumber all real and personal property owned by the debtor include a mechanics lien, attachment liens, mortgage liens, or judgment liens. The correct answer is D. Judgment liens. Which of the following is incorrect concerning a conventional life estate? A. The owner is called the life tenant. B. The owner does not have to die for the estate to end. C. Life estates always pass to the remainderman. Or D. A life estate may be sold, leased, or mortgaged. C. Life estates always pass to the remainderman. Concerning liens, which of the following is incorrect? A. Liens are always encumbrances. B. Liens are either equitable or statutory. C. Liens increase the value of property. Or D. Liens are either specific or general. C. Liens increase the value of property. What do dower and courtesy rights have in common? A. Legal life estate. B. Possessory estate. C. Leasehold estate. Or D. Remainder estate. A. Legal life estate. Jim is an electrician who was hired by ABC Construction to install all of the electrical wiring in a new home. Jim began the work on June 10th and completed the work on June 15th. The closing took place on August 20th. If Jim was never paid by the general contractor and wishes to file a lien, the effective date would be, again, Jim is an electrician who was hired by ABC Construction to install all of the electrical wiring in a home. Jim began the work on June 10th and completed the work on June 15th. The closing took place on August 20th. If Jim was never paid by the general contractor and wishes to file a lien, the effective date would be A. June 10th against the property owner, B. June 10th against the property, C. June 15th against the general contractor, or D. August 20th against the new homeowner. B. June 10th against the property. A freehold estate is defined as one that A. has a condition attached to it, B. includes an estate for years, C. is similar to a leasehold, or D. will last indefinitely. D. A freehold estate will last indefinitely. The Joneses have purchased an acre of land in Elite Acre subdivision and are aware of the fact that the covenants might limit the ways in which they use their property, which is true of private restrictions. Again, the Joneses have purchased an acre of land in Elite Acre subdivision and are aware of the fact that covenants might limit the ways in which they use their property, which is true of private restrictions. A. The covenants cannot restrict the type of architecture they choose for their home. B. There could be a restriction on selling the home within the first 3 years after it is constructed. C. If a covenant specifies 1 acre of land per dwelling but local zoning permits 2 houses per acre, they can build 2. Or D. Covenants can be based on aesthetic considerations. The answer is D. Covenants can be based on aesthetic considerations. An easement may be created in any of the following ways except a reservation, necessity, grant, or merger. D. Merger. The total collection of rights that may be claimed by private ownership is described as A. The fee simple system, B. An estate, C. Freehold, or D. The bundle of rights. D. The bundle of rights. A remainder estate may exist at the same time with all but one of the following: A. Fee simple absolute, B. Life estate, C. Fee simple on a condition subsequent, or D. Fee simple determinable. The correct answer is A. Fee simple absolute. Which of the following would be a less than freehold estate? A. A life estate, B. Leasehold estate, C. Fee simple estate, or D. Fee simple determinable estate. B. Leasehold estate. All of the following can be acceptable methods of terminating an easement except A. Abandonment of the easement by the owner of the dominant estate, B. The owner of the servient estate openly and continuously prevents the easement owner from exercising his or her right of use for a statutory period of time, C. Express release to the owner of the servient estate by the owner of the dominant estate, or D. Revocation of the easement by the owner of the servient estate. D. Revocation of the easement by the owner of the servient estate. The types of leasehold estates include A. Estates from period to period, B. Estates for years, C. Estates at sufferance, or D. All the answers are correct. D. All the answers are correct. The government's right to make laws and regulations for the general welfare is known as A. Eminent domain, B. Police power, C. Escheat, or D. The bundle of rights. B. Police power is the government's right to make laws and regulations for the general welfare. Which of the following is an estate in land? A. Easement, B. Lien, C. Encumbrance, or D. Lease. D. Lease. The City of Atlanta has condemned Nelson's Land in order to extend its rapid transit services. This procedure is made possible because of the city's right of A. Entry, B. Escheat, C. Eminent domain, or D. Police power. C. Eminent domain. A private landowner has the right to A. Reject a claim for taxes, B. Repudiate its zoning ordinance, C. Disinherit heirs, or D. Refuse to sell the property or otherwise prevent the city from taking it for use as a street. C. Disinherit heirs. Except for property tax liens and in some cases mechanics liens, priority of liens is determined by the A. Amount of the debt, B. Date of default, C. Date of recording, or D. Court at the time of foreclosure. C. Date of recording. Farmer Brown is tired of hard work. He is deeding 165 acres of his farm to his son and keeping only 5 acres and a house for his own use. He will need an easement across his son's land so that he can get to his own. How is the easement created? Again, Farmer Brown is tired of hard work. He is deeding 165 acres of his farm to his son and keeping only 5 acres and a house for his own use. He will need an easement across his son's land so that he can get to his own. How is the easement created? A. Through a reservation in the deed. B. By having the son sign a lease. C. By recording a new plat map and survey. Or D. Through an exception in the deed. The correct answer is A, through a reservation in the deed. Smith signs an agreement with Jones to use and possess Jones's land until May 1st. Their agreement creates a less than freehold estate for Jones, a periodic tenancy, an estate for years, or a revisionary estate for Smith. C. An estate for years. All of the following can be characteristics of an easement except A. An easement creates an interest that may be protected from third-party interference. B. An easement can be created by conveyance. C. An easement is an incorporeal right to the land of another. Or D. An easement may be revoked at will by the servient landowner. D. An easement may be revoked at will by the servient landowner. Revocable permission granted to hunt on another's land is an example of A. An incorporeal easement, B. A license, C. An easement by prescription, D. An easement appurtenant. B. A license. Telephone lines are examples of A. An easement in gross, B. A legally valid encroachment, C. An easement appurtenant, or D. A non-revocable license. A. An easement in gross. An easement created for the purpose of giving an owner ingress and egress to his or her landlocked property is an easement in gross, an easement by subscription, an easement appurtenant, or D. An easement abandonment. C. An easement appurtenant. A right or claim of a creditor to have a debt satisfied from the proceeds of the sale of the debtor's property in the event of default is A. An attachment, B. A judgment, C. A writ of execution, or D. A lien. D, a lien. In real estate law, the word fee is closest in meaning to possession, an estate of inheritance, a tax or assessment on land, or a real estate commission. B, an estate of inheritance. The laws allow a person furnishing labor or materials for the improvement of real property to file a mechanics lien against the property so improved if she is not paid. Which of the following is correct concerning such liens? The law allows a person furnishing labor or materials for the improvement of real property to file a mechanics lien against the property so improvement if she is not paid. Which of the following is correct concerning such liens? A, a mechanics lien takes priority over all other liens. B, a mechanics lien is a general lien. C, a mechanics lien filed by a subcontractor is ineffective against a property owner who has proof of having paid the general contractor. Or D, a mechanics lien will expire if the claimant does not take the necessary steps to enforce it. D, a mechanics lien will expire if the claimant does not take the necessary steps to enforce it. Unauthorized intrusion of a building, improvement, or other attachment onto a neighboring land is an easement, an encroachment, a lien, or an estate. B, an encroachment. Which of the following phrases would be most typical of a fee simple determinable estate? Provided that, on the express condition, with the intention of, or for so long as. D, for so long as. Encroachments are usually discovered by A, title search, B, physical inspection, C, survey, or D, recording. The correct answer is survey, C. Ned owned 50 acres with frontage on Slater Mill Road. Ned sold the front 30 acres to Smith, but reserved an easement for the right of access to the back 20 acres. Which of the following is not correct? Again, Ned owned 50 acres with the frontage on Slater Mill Road. Ned sold the front 30 acres to Smith, but reserved an easement for the right of access to the back 20 acres. Which of the following is incorrect? A, Ned has a dominant estate. B, Smith has a servient estate. C, Smith's estate is subject to Ned's interest. Or D, Ned's estate in the 20 acres is subject to Smith's interest. D, Ned's estate in the 20 acres is subject to Smith's interest. And that's all I have for today's topic, folks. Thank you for studying with me, and don't forget to like and subscribe for more content.